Welcome to Employment Law This Week. I'm George Whipple. Our top story, your chance to weigh in on the new National Origin Discrimination Guidance. The EEOC is soliciting public comments on their proposed new guidance until July 1st. Approximately 11% of the private sector EEOC charges filed in fiscal year 2015 were national origin discrimination claims. The new guidance addresses issues like human trafficking, accent discrimination, and job segregation. Here's Richard Palmer with more.
The new guidelines are similar in scope to the guidelines issued back in 2002. However, some areas have been expanded and there are some new areas altogether. One area where an employer may want to provide comment relates to customer preference. As written, it is unlawful for an employer to base an adverse employment decision on the preference of a customer to deal with someone without an accent. In addition, the proposed guidance contains a new section called Promising Practices. I encourage employers to review these practices and comment if you believe that these practices are overreaching.
Cash substitutes for health benefits must be included in employees' regular rate calculations. That's according to the Ninth Circuit Court of Appeals in a case of first impression. The city of San Gabriel allowed police officers to choose cash payments in lieu of health coverage. The city treated these payments as health benefits, which are not factored in to an employee's FLSA overtime rate calculation. A group of officers sued, and the Ninth Circuit found that the payments were compensation for work and must be included in the regular rate calculation. The NLRB finds the hiring of permanent replacements for strikers to be an unfair labor practice. In a 2-to-1 decision that could benefit unions during contract negotiations, the board found that a continuing care facility in California violated federal labor law when it hired permanent replacements after a series of intermittent strikes. While the board and courts have long held that an employer's motivation in hiring permanent replacements is irrelevant, in this case, the board held that if the hiring is motivated by an intent to discourage future strikes, it interferes with employees' rights under the NLRA. The employer in this case will likely seek judicial review, but in the meantime, the decision adds new risk for employers who may wish to hire permanent striker replacements. The Fifth Circuit upholds a microunit at Macy's. In 2014, the NLRB certified a collective bargaining unit consisting of 41 cosmetics and fragrance department employees at a Macy's store in Massachusetts. Macy's appealed, arguing that the union had strategically selected a department with many pro-union employees, and that the board should not have certified any unit that did not encompass all store employees or at least all selling employees. The Fifth Circuit disagreed, upholding the NLRB's original decision that the employees in question had distinct interests and did not share an overwhelming community of interest with other workers. And that brings us to our tip of the week. David Sherwin, director of the Cornell Institute for Hospitality, Labor, and Employment Relations, is here with some advice for employers in light of the Seventh Circuit's Epic Systems decision covered on last week's show.
The Seventh Circuit's decision in Epic has made employers rethink their mandatory arbitration policies. So employers right now have to ask themselves, what should I do with my policy? Well, if the main point of your policy is the class action waiver, the first thing you have to decide is whether or not there's a way to ensure that it will be enforceable. If employees have 30 days to decide whether or not they're going to opt out, then the argument is that the policy is not mandatory and wouldn't violate the NLRA. If the bigger issue for the employer is the individual claims, then the thing that the employer needs to make sure of is that they are in a jurisdiction where the courts will so-called blue pencil the agreements. A blue pencil would mean that they would strike the class action waiver but continue to hold the individual claims enforceable.
Thanks, David. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.